My name is Marty Shenkman. I'm joined by my partner, Thomas Tietz, and we're going to talk about a topic that everybody knows everything about, and it's been around forever, but we're going to try to focus on some interesting applications that may be a little different than routine, and that is revocable trusts. So we believe that there are opportunities, probably many opportunities, to enhance and improve the application and use of revocable trusts in estate planning. We're not in any way against revocable trusts. Tom, I don't know if you do, but I can say that my wife and I both have revocable trusts, and we've transferred and funded them with most non-retirement assets that aren't in irrevocable trusts. But I think with some additional creativity and thought, there's other things that can be done with revocable trust other than just avoiding probate. And that's really what our focus is. Tom, do you want to make any comments as we start to get started here?
One of the things when it comes to dealing with revocable trusts is helping the clients understand these advantages beyond probate. Because when you look online, a lot of what you see the discussions on is about avoiding probate. So the ideas that we're going to be talking about today are points that you can bring up with your clients about revocable trusts. And as we go through these, we'll bring some advantages in the jurisdictions that we practice in that we are why we use them, but you may think of some points that are salient for your particular jurisdiction that you can also talk about.
So typical revocable trust, one spouse creates a revocable trust for another, for each other, and name each other as successor trustee. We're going to talk a little about that. I think too many clients, too many consumers feel and believe that a revocable trust is necessary to avoid probate. I think everyone knows it's not. You can have assets titled jointly in trust 4, pay on death 2. The problems with those types of titles, while they can avoid probate, the assets end up outright in the hands of the beneficiary, whereas using a revocable trust to avoid probate gives you a better option from the standpoint of being able to fund long-term protective trusts. I think that clearly a revocable trust is a powerful tool, but it doesn't substitute for full planning. So, if the client's estate, if the individual's estate is large enough, they should be doing estate tax planning. And by the way, that's not just at the federal level, and the current exemption is 15 million inflation adjusted. There's been proposals already to reduce that dramatically. Many states have lower thresholds. Having the best revocable trust plan doesn't substitute for having proper long-term care, medical, liability, property, disability insurance, financial planning, retirement planning, all the other stuff. And as the last bullet point says, what are your real needs? All the other components to what constitutes or makes up or comprises a holistic, comprehensive plan, all that should be done. And the revocable trust can, and for many clients, not all, should be part of that. But I think we can go further. So one of the things that we're going to talk about, Tom, I'll let you start for it, is one of the common and I think very powerful uses of a revocable trust is addressing, I'm going to say, the issues of aging, but it's not only aging, it's also anyone that has cognitive or chronic disease, disability issues. Tom, why don't you talk a little about that, and I'll chime in periodically and give you a hard time.
It's always fun when you give me a hard time, Marty. So elder abuse is continuing to increase, and the financial repercussions of it for our clients is significant. AI, as an example, has created a force multiplier effect for bad actors when it comes to elder abuse. It helps them identify people that may be in vulnerable positions. It helps them with generating the kinds of aspects that would actually cause them to get caught in the traps, whether it's phishing emails, whether it's financial scams, whether it's making things seem more legitimate when they speak to them. A revocable trust can help put guardrails on the kinds of issues that might cause elder or financial abuse. It also helps with the transition when it comes to somebody taking over for the client when they can't deal with the financial issues themselves. one of the axioms that we often use when we say this is it's like in a relay race when you have the passing of the baton. That's one of the most sensitive and weakest points in a financial plan, when it's going from the client to whoever's going to be dealing with taking care of the finances after the client can't do it themselves. So having the revocable trust there helps with really making that transition smoother and reducing the chance of problems there.
Let me explain how that's done. And it's really obvious and it's not complicated, but I think sometimes stating the obvious can even be helpful. So if a client is starting to decline cognitively, physically even, because then it may be harder to just deal with the mechanics physically of handling financial affairs, it's not, as so many people incorrectly assume, like a light switch. Today I'm fine, tomorrow I'm not. It's often imperceptible changes over sometimes a lengthy, sometimes shorter period of time. The light switch is an apt description when there's a traumatic brain injury resulting in a problem, but that's a very small percentage. So the real power of passing the baton, using the phrase Tom used, which is good, is practitioners in all the different disciplines, clients themselves need to evaluate, how am I really doing? Not how I think I'm doing or how I want to be doing, how am I really doing? If I'm starting to fade or have issues, maybe what I do is I make a co-trustee to serve with me. So there's somebody already in action and somebody whose name is on the accounts at the different financial institutions to start the process. As you go down the continuum of decline, at some point, maybe the individual who's the settlor should not even be a trustee, but you can certainly start as a co-trustee. So, you know, you can certainly, and we'll talk about it, have a trust protector who can remove and replace. But I think a conversation that everybody should have with every client as they get on in years, or if they have any health issues, which is an awful lot of people, is, hey, do you think it's time to bring on a co-trustee or even resign as trustee? It's a lot easier for somebody to sign a resignation or to appoint a co-trustee while they're well than to deal with those issues when it's not. Just very quickly, obviously more than just a trust document is necessary, and we're going to talk about applications and modifications to the typical revocable trust to help, but keep in mind that you need more than just the trust document. Consolidating and simplifying financial accounts. I like when clients consolidate their financial assets so there's one, maybe two different institutions. The less the better, because it's easier for clients as they start to decline to keep tabs on everything. Having an independent CPA, if the financial resources permit it, monitor financial transactions can be very prudent. Obviously, for people of lesser means, you could have a family member, you could have duplicate copies of statements sent to somebody, you can give a trusted person access to see your statements, and you can build in some checks and balances by involving different people. But there's really nothing better than having, at some stage or age of decline, an independent CPA monitor, and especially if they have no access to anything where they can undertake financial transactions, have them monitor it and issue a report, perhaps to the client, the settlor, to a trust protector, maybe to somebody else, so that there's checks and balances in different people. We're going to talk about this, I think, further, but you can bake into the revocable trust structure the requirement that for certain significant actions, the consent of an independent co-trustee or even an independent non-adverse party, like a professional advisor, is required for certain transactions. And we're going to come back to that. You can use a separate trust tax ID number. Well, if I'm my own trustee of a trust that I'm the beneficiary of and the settlor of, you don't really need a separate tax ID number, but getting a different tax ID number, and I can only speak anecdotally, my belief is, I have no way of proving it, that when you have an independent tax ID number, it's a bit harder for somebody to scam the accounts because that number is less accessible or identifiable than a social security number. Tom, why don't you comment for a minute on using a tax ID number and some of the points that may create?
I'll just comment more from a human perspective when you're looking at this. For many clients, it's difficult to realize that they're declining cognitively and to actually give up financial control. You can liken it to when somebody has been driving their entire lives, but they really shouldn't be driving anymore, and they take the action of giving up the keys. They're not going to want to say, I can't do this anymore. Using the revocable trust as its own kind of vehicle, to continue the car analogy here, helps build in steps that protect the client without them saying, I'm completely not involved anymore. It's not, like Marty said, a light switch here. This is a gradual increase in the ability for people to help you. It's building those guardrails in, and that's the way you can coach it to the client. You're not giving up your financial life. You're not giving up the ability to control your life here. You're having people help you, and that's what this is being built for.
All right, let me just, now I'm embarrassed. I spilled water from my water bottle, leaked out on my shirt. I'm gonna tighten it. It's embarrassing, so now I've said it so I can forget about it. Sorry, everybody. Trustee selection. So the most common approach that we see all the time with revocable trusts is, let's say Jane and John are married. Jane will be the trustee of her trust, followed by John, her spouse, and John will name himself and then Jane. And I see a lot of them just stop there. That's not really secure enough. What happens if something happens to both of them? What if, God forbid, they're in a car accident? Who's really there to take over? What's the transition plan? It's easy, it's simple, and you can do a revocable trust and they can go home thinking they've avoided probate, but they haven't really created the succession and protection for cognitive issues, decline coming with aging or chronic disease or disability. You need a trustee, and often you need more than just a trustee, because you may want to have an independent trustee and a family trustee. What you use for trustees really depends on the circumstances. This is something that is, financial advisors are making huge inroads and being more involved with estate planning. This is such a critical and helpful discussion to have. If a financial advisor is meeting quarterly with a client and the client hasn't been back for years with a lawyer, have the discussion. Are you still able to serve? Are you worried about how long you can serve? Who can you name? Why do you only have you and your spouse? You don't need to use, complex AI software to analyze all the trust provisions. I mean, you can do that too. Just remember to stay behind your skis, not over your skis. But this is such a vital issue and it doesn't get enough attention. Should we name an institutional trustee? Should we name somebody from my spouse's oldest kids or my oldest kids, or name somebody completely independent? Every professional in all the disciplines knows a lot of these issues, but too often the tougher conversations with the client, who to name, and here's one that I see all the time. Okay, you want to name your oldest daughter Jane. Okay, does she really have the time to do it? She's a mom, 3 kids. She runs marathons and she's working as a physician. How is she going to take on this additional burden? Maybe name Jane if she's the only person you can name, along with a professional trustee. This way, the burdens of some of the time demands and administrative functions are taken off of her, but she can be there to help protect you. These discussions are obvious, they're known. I don't know that I'm adding much to them, other than the point that we see it done less than optimally with a lot less thought. Many times clients just like the quick, easy answer, because then it's not these tough, really hard decisions. Oh my, if me and my spouse are both incapacitated, oh my, what do we do? But those are the discussions you need to have to make this all work.
To go further beyond that just a little bit, sometimes if one of the partners, one of the spouses is incapacitated, that creates a problem in and of itself. There have been many times where I've been sitting down with a couple and one of them is the one that deals with the finances. I turn to the other spouse and I say, if something was to happen to your spouse tomorrow, would you be able to deal with all the financial aspects? Do you know where everything is? And most often I get a deer in headlight look whenever I ask that. So talking with clients about organizing the information, not just for the successor trustees, if both of them are incapacitated, but maybe for their spouse as well, will help them more than just avoiding probate with a revocable trust.
And when you have that conversation, if a decision is made that an institutional trustee or a more distant family member may be named, and the client has some discomfort with that, if you're the financial advisor, accountant, insurance consultant talking to the client about this because you have a good relationship, maybe at that point you can flip it by saying, hey, I understand your discomfort with naming a cousin because you don't have closer family members. Talk to your estate planning attorney, and maybe some safeguards can be built in: a trust protector, mandated reporting requirements, restrictions on changing certain transactions or actions. So there's lots of things to do, and it does vary materially from client to client. We need to have these discussions. Tom, you want to talk about accountability a little bit?
So a couple of thoughts of accountability is, like Marty mentioned, we can build guardrails and protections into revocable trusts that create additional flexibility here. You can create a monitor that can look through the finances. You can create required reporting. And there, like anybody that's named as a trustee, as we all know, would be a fiduciary. So they have to put the benefits of the beneficiaries above anything that they could get. So even if a child, and this is something you can help to assuage the concerns of the client in this situation, even if you name a client, they need to take care of the entire family and obviously the clients first in that situation.
Let me explain one of the sort of conflicts that comes with a revocable trust. So Jane is single, and she names her oldest of 4 children, John, to be the trustee. John, the oldest son, is the trustee, but he's not a good guy. And he kind of feels like, gee, he's doing all this work for mom, and the other kids aren't really doing anything, and he has all these responsibilities. And he very well may, and he may be, taking on a real burden in caring for mom. But in some instances, people in those roles feel that they're not being given the acknowledgement, and often it's not even just financial, it's the emotional acknowledgement, respect, gratitude from the other siblings for all the burden that they're carrying. In other instances, and it's the whole spectrum, they may not be doing all that much but feel they're doing a lot. But what if John, the oldest kid that's the trustee, starts to pay for expenses that get very questionable as to whether they're really for mom or for him? And what if it starts to look like he's actually doing inappropriate financial or other matters? Or what if he's not taking anything inappropriately, but he's not really using the money that's there to properly take care of mom, and she's not being cared for the way she should? Part of the problem is that a revocable trust historically is exactly what its name implies. It's revocable. So until the settlor dies, what rights do the remainder beneficiaries, in my hypothetical, the other 3 kids, have? Sometimes there's not much, maybe none. So if you're in a situation where one kid is acting inappropriately and the other kids may not have legal standing, is the word, to sue, what recourse do they have? There's also the financial realities of it. If somebody, John in our hypothetical, is the trustee, and he's doing bad stuff, and the other 3 kids say, hey, you're not taking care of mom, and they have to file a suit because John is not interested in talking to them about what's being done, John is going to use monies from the trust to hire counsel to deflect and defend against the lawsuit from his siblings, whereas the siblings have to come out of pocket for the money to hire a lawyer to go ahead and do that. And financially, that dynamic alone can make this impossible. That is one of the reasons why we include in many, if not a significant majority of revocable trusts, a trust protector who can require an accounting, remove and replace the trustee, because if things are not being handled properly, you want to check and balance on that. Tom, you want to talk about monitor a little bit more, institutional trustee or professional trustee, some of these other steps that could be taken?
I think that we've covered it pretty thoroughly at this point, but it's just something that's worthwhile to talk with the client about. Even if they don't want to name an institutional trustee, or if they don't have anybody to name as a trust protector now, including them at the very end. So maybe they want Uncle John and Aunt Jane as successor trustees after both of them. But after that, if all of they cannot serve, then an institutional trustee will come in. And maybe they can't name a trust protector now, but in that situation, we tell our clients, we'll include the trust protector provision so that the language is in here, the authority is in there, and we will give you the ability to name an individual in a written document at a later time. That way, the bones are built into the actual trust document, and it's ready to be activated at a later point as the client gets on in later years. What I like about that is if a client is generally younger, they may not need the aging aspects of a revocable trust at this time. It's there and ready to be activated as they age. It kind of lets the trust grow with them as they grow.
I think as a general statement, there's not enough discussions of these safeguards. Too often they're not included in the standard or typical or common revocable trust. It doesn't take a lot to do that. And I think, and I'm repeating what I said, but I think it's just so important. It's not just the attorney that should have these conversations, because the client may not come back to the attorney for 5 years, 10 years. We've seen 20 years after drafting a document, and the attorney may have no idea that the settlor is starting to fade or experiencing cognitive issues, etc. So any advisor that picks up on this, start the conversation, and you can obviously direct them back. So I'm going to comment on this because this is me. I have an institutional trustee or co-trustee, not only on irrevocable trusts, so that I can get situs in better trust jurisdictions, but I have them on all family trusts, because one of the things that I've seen in 40 years plus of practice is there's just, it seems to be endless, the variety and the creativity with which family trustees can create problems with the trust instrument by violating the trust instrument, by doing things wrong. Just it's almost endless, it seems, the kinds of mistakes and errors they can make. And those errors sometimes are harmless, sometimes they're comical, a lot of times they're devastating financially. So I like using an institution. Many people, and again, I know this is obvious to everyone listening, but I think it's an important conversation. And let me state again something that's obvious, because I think it's an important conversation to have with clients. If you name an institution, many clients feel, oh my, the institutions, they're not personal, they're rigid, they're not going to be flexible. Well, a trust protector can remove and replace them, but you still have the institution. And sometimes that rigidity and stuck in the mud kind of view that some people have of an institutional trustee, that's a good thing. That's how they provide safety and security. So if an institutional trustee is not going to make a distribution until their distribution committee meets and reviews the request, and they may ask for backup information, that process, and that's a key word, process, is what helps protect the settlor from somebody committing elder financial abuse and getting them to request distributions, or romance scams, getting them to make distributions to the settlor that they then pilfer. So, you know, a lot of times the thoughts of using an institution, oh my, they charge, but family members often charge too. And there's nothing wrong with paying if you get an extra layer of protection. One of the reasons this concept is so important, and I'm sorry to belabor it, but it is so important. One of the fastest growing demographic cohorts in our country, and I hope I'm saying it right, I don't have the statistics in front of me, but is single women over age 85, because they may outlive their spouses, they may outlive some of their friends and family members, and who do they name? And if they don't have an institution, who's really going to protect them? Is naming a neighbor in your apartment building or a third cousin really appropriate? Maybe. But is it safe? Maybe, maybe not. So these are really important conversations. So um, I think we've talked about this, but one last point. It's important not just for next gen to understand the wealth that may be coming to them so they're prepared, but it's really important to protect the person, the client, the settlor creating these trusts to have periodic web meetings. The internet and Zoom meetings, web meetings, team meetings, whatever software you use, have really made it easy and inexpensive from the standpoint that you can get advisors all over the country to get on a half an hour's web meeting and chat about what's going on and maybe have key family members, trustees, and others involved so everyone knows their role, everyone understands if anything's changed. All the advisors can view the status of the client and see if anything has changed. Tom, let's talk a little more, and I'll let you take the charge on trust protectors and some of the powers they can be given, some of their roles. I know you already mentioned that some people can't think of somebody, so we just bake in the mechanism. But give a little more background about this. And just as the setup for this, everyone, trust protectors seem pretty commonly used in more complex irrevocable trusts. And I think in that application, it's flexibility. What if the tax laws change? What if we need to move to another jurisdiction? Those points may still be relevant in a revocable trust, but I think, and you can talk about it a little more if you feel necessary, Tom, it's a somewhat different context of what role the trust protector serves in a revocable trust.
So I agree. I believe in some ways it's a greater role in a revocable trust because a revocable trust will change throughout its lifetime. We're talking about during the settlor's lifetime at this point, but consider the fact that every revocable trust will eventually become an irrevocable trust. Explain to the client this is not just for your lifetime, but it's for the trusts that are created for children if you keep them in dynastic perpetual trusts at that point, which is helpful for asset protection and other considerations for the beneficiaries. But that may help the client understand we want these provisions in there. But this gives us flexibility with this trust. We will include powers for our trust protector to deal with moving the trust to another state, moving it to a jurisdiction with better trust protections, like Alaska, like Nevada, like Colorado, like Wyoming. There's many different ones that have these kinds of protections there. So as maybe the client moves and they want to move the trust itself and they don't want to just completely restate it, they just want to have the trust protector deal with that. That might help them with moving it there. There's also a consideration if you have a client that has special needs children or special needs challenges, you can have a trust protector revise and change those provisions in the trust, and that can be active during the time that the client is actually still alive. So that could be helpful there as well. And of course, the ability to remove and replace the trustee. An interesting point, and this is something to discuss with clients, do you want to give the trust protector the authority to remove and replace you, the client, as trustee? We were talking earlier about clients may not understand or realize when they're starting to fade. If you have somebody that you have concerns about, the trust protector can be a neutral third party. There's still somebody that knows the client very well, but a neutral third party that can choose to pull the trigger of either adding a co-trustee to serve with the client or outright removing the client from serving as a trustee if they have serious concerns there. Giving them the ability to demand an accounting is one of the ways that they have the power to be able to make those decisions. So it really fleshes out and prevents holes in the mechanisms that you create with a revocable trust that may have been there with just a traditional trustee. It's a very solid check and balance to include in the trust.
Tom, did you talk about fiduciary versus non-fiduciary capacity?
I did not. Good point there, Marty.
So let me just explain. I know that a lot of practitioners, when you're creating a trust protector role in a irrevocable trust, like the trust protector to be able to act in a non-fiduciary capacity. And some of the reasons for that may be, well, it may entice the person you're naming to serve because they don't have any fiduciary responsibility. I think you could argue it may give more flexibility because I'm not bound by a fiduciary standard. I don't know that it's the same analysis in the context of a revocable trust, because the revocable trust is not a permanent feature to save a state tax or for asset protection, but more to protect the individual, the person, the settlor, the trustor, the grantor creating the trust. And if you have wealth in a revocable trust, and that's really your safety net financially, not a complex tax plan, you may not want someone to have the authority to act outside of a fiduciary capacity because you want them expressly held to that level of loyalty and duty to you in a fiduciary capacity. So I think that's one of the differences to think about when creating a trust protector role in a revocable trust. There's another role that is almost never talked about, and for some, I don't know if it's many, it's certainly not most, but for some clients is potentially very valuable and helpful. And keep in mind the vulnerable, isolated, elderly client. So if you name a child, or even more concerning, someone less close perhaps, a cousin, a niece, a nephew, as the successor trustee to you, how do we know? How does anyone know? How can we provide a safeguard, a check and balance to make sure that you are being cared for if you're struggling with disabilities, chronic disease, cognitive issues, etc.? You can bake into the trust instrument a mandated periodic evaluation by an independent care manager. This should not be, I wouldn't structure this where the care manager is a person providing ongoing care to the client. I want somebody independent. I want to require that they physically, not by a web meeting, physically meet the settlor, and it could be for other beneficiaries as well, in the place where they're living. And maybe you do it annually, maybe you just bake it in but don't start it until a future date. Maybe for some people, if there is more concern and they're struggling with cognitive or health issues in a material way now, quarterly or even monthly, whatever is appropriate. And a care manager is a independent licensed social worker, a registered nurse, etc. And there's other designations, and there's care management designations. But the point is, you're now having an independent person meet the subject, the settlor, in their home or residence, wherever that may be, and doing an evaluation, and then issuing that report perhaps not only to the trustee of the trust, so that could be valuable information about care and the care plan, and they can make recommendations about modifications to it, but perhaps also to the trust protector if one's named. Perhaps also to the healthcare agent who may be a child, even though the trust protector and the trustee are different people. So now if you have an independent care manager issuing a report periodically, and it's going to several different people, if there's a gap in the plan or this person is being physically or otherwise abused, that can come to light. It's a great safeguard. Tom, you already mentioned the monitor, so I'm just going to briefly mention. In the bottom is a reference to the New York Power of Attorney statute that permits the appointment of a monitor. And what we're suggesting is you could, if you choose, have an additional party appointed to provide yet another check and balance on top of the trust protector. So for example, maybe the trust protector is an independent attorney and the monitor is an independent CPA. They could be ongoing advisors who know the family and know the settlor. How far you go really depends on the risks and concerns of the client. But many clients, as they get on in years, have experienced or heard stories of friends, family, and other people they care about who've really had some very bad things happen. So you can offer whatever degree of checks and balances that the client feels comfortable with. And obviously there's going to be a financial consideration in all this, because if you name, and I'm just making up positions in terms of the attorney being the trust protector, the accountant being a monitor, and a care manager, you're creating some professional fees and costs. But I would suggest that even for more moderate estates, the cost of having these safeguards and paying people to perform in these functions probably pales by comparison to what can be done financially to them in the event there's a problem. Again, if you look at the statistics, and I may have had them earlier and just didn't focus on them, but the amount of wealth that is lost to romance scams, identity theft, elder financial abuse, and it's not elder only financial abuse, it's financial abuse of anyone that's infirm. These are all really shocking in terms of dollar values. We devote so much time and effort to planning for estate tax, and I think if you look at the dollars lost to all these other causes, it eclipses the estate tax cost.
So
Tom, do
quick
you
point
want?
I want to make
Yeah.
before we move on here, Marty, is oftentimes we as practitioners will talk about building a advisory team when it comes to helping clients with avoiding estate tax. That may include the wealth advisor, the attorney, the accountant, maybe there's an insurance agent involved. So we have often talked with clients about building advisory teams. What we're talking about here for the revocable trust is just another kind of team that's being built to protect the client. The care manager works with the trust protector. If you included a monitor, they're a part of the team. So this is just another way to safeguard and protect the value that the clients have built throughout their lives.
Tom, do you want to comment on the non-adverse party consent? Do you want me to do that?
I'll get it started, Marty, then you can kind of talk about the ideas you've had, because you've thought of some great ideas of people to name in this position. So consider a client that has a revocable trust and maybe they have a deceased spouse. So they are now single. We're going back to the women above 85 that are single at this point. If they get remarried, there may be a possibility that their new spouse is going to try to convince them to change the revocable trust, or there may be the romance scam that Marty talked about earlier, some sort of undue influence. People often will change their wills because of situations like this. If you name a person in the revocable trust that needs to basically authorize a modification or consent to a modification or revocation of the trust, that's building another safeguard against somebody being taken advantage of. So once again, it's many different levers or tools that we can build into these revocable trusts that protect clients. And Mari, I think you had a good idea when it comes to an individual you can name in this position for a revocable trust.
Another, and forgive me, I want to repeat it, but I think it's really important and it gives a framework to what we're doing. The point of what we're trying to do is not talk about the general use of revocable trust, but how they can be enhanced and made more powerful and more helpful and more protective of the clients creating them. And I've actually seen it in a different context than Tom named. For me, just over the decades of my practice, I've seen a sad, disturbing number of times where a home health aide has become very close to the client, the settlor, the testator, the person creating the will, and clearly it's a private relationship. There's clearly undue influence, and they've managed to be able to take that individual to an attorney, and I don't know how the attorney could possibly make any inquiries and not see how inappropriate it is, but the attorney does a new will that either cuts out or reduces or eliminates entirely, in some of the cases I've seen, the family or the charities that were named, and then in turn what happens is the home health aide is named in that capacity of a beneficiary. Very worrisome. If before that could be effective, if you want to change or revoke, modify or revoke the revocable trust, an independent person, the attorney, has to approve it, then there's going to be another safeguard to just simply revoking and modifying the plan and the trust. Another consideration, and this is just thought, not something I've seen done yet. What about naming a religious advisor? You know, if somebody's getting on in years and is struggling with challenges, if they're a member of any particular faith, they may well have a monthly visit from their religious advisor, whatever role or title that may be. That person may be somebody, or you can name the lawyer and the religious advisor. The point is, it's another mechanism that doesn't get addressed enough and can be a very powerful tool to help protect aging or infirm clients from the kind of abuse that has become sadly very, very common. Let me just mention the next one on page 21. So, and let me give some context. And Tom, why don't you give the context about what's going on tax-wise in the country in the recent proposal from Van Hollen, just to show why something like this might be so important.
So right now, many clients have been saying to us, there's a $15 million federal exemption. I may live in a state where there's no estate tax. Why do I need to plan? I'm well below that amount. I don't need to worry about it. If you look at what the proposals are out there, what Democrats specifically have been doing in states, as well as the Van Hollen proposal that Marty mentioned, it's all about reducing the estate tax and also taking away the tools that us estate planners can use to shift wealth. The most recent Strengthened Social Security Act proposal that was put out there by the Democrats would reduce the federal exemption to 3.5 million, and most interestingly, decouple the gift tax exemption and reduce that to only $1 million, as well as get rid of many of our tools that we use to shift wealth. That's a significant reduction right there. And they did something that they've not done in the past by linking the estate tax to the solvency of Social Security. So there's some strategic discussion and planning that is going into these proposals. And while it's unlikely that any of these proposals will be enacted under the current administration, this is showing where the Democrats on a federal level are looking to go. Then if you look at all the various state proposals that we have out at this point, I believe, and Mar, you can quote me you can correct me if I'm wrong, it's Washington that recently enacted a 30%, Washington State that recently enacted a 30% state estate tax. That's in addition to the 40% federal estate tax that you would have. You have in New York, the New York City Mayor Mamdani recently proposed reducing the New York state estate tax from 7 million and change to 750,000, not inflation adjusted. There are other proposals that have gone out recently as well that are continuing in that same vein, and it shows that the general momentum when it comes to estate taxes, both federal and state, seem to be going towards making them more restrictive, lower exemptions, and greater tax burdens for taxpayers.
So there's a simple step you can take because we don't know what's coming down the pike. So let's say a client has an estate where they're not worried about taxes right now, but if the exemption were reduced from 15 million inflation adjusted to 3.5 million, 5 million, whatever the number, what if they're incapacitated and can't plan at that stage? If you build into the revocable trust the mechanism that permits a division of the trust into two trusts and the right for a power holder to revoke the settlor's access to and rights to revoke or modify the trust, that portion of the trust, and I started by saying to divide the trust because they may want to divide it into two pieces and revoke the settlor's access and control over one piece, but not over the other piece. But the concept is to create a party, a power holder that has the authority to make a completed gift out of some portion or all of the trust, depending on future circumstances. It's a way to create some additional flexibility to accomplish estate tax planning before change in the law may become effective. Now, in lots of most maybe revocable trusts, you know, there's GST planning and long-term trust for heirs and so on and so forth. But this is another aspect of how tax planning can be integrated.
And an interesting point on that particular topic, if there is a proposal, let's say, because so often this happens, there's a proposal in November and it says that the changes are going to be effective January 1st. With the deluge of planning that's going to happen, you may not have the time to get an irrevocable trust established and funded, even if there are assets outside the revocable trust. Having this trigger in the revocable trust with the provisions that the client is comfortable with, it may be a faster mechanism that can be used to do planning in a way that you would not have been able to get done if you did the traditional establish an irrevocable trust and fund it at that time.
So the next topic is sort of an extension, a little more detail on something I said earlier. Revocable trusts are a powerful part of planning. Yes, I think it's great to minimize and reduce probate costs and probate publicity and probate time. It can simplify estate administration if the assets are in a revocable trust, and so on and so forth. But I did make the comment, which I'm sure everybody knows, and it's obvious, that you still need a comprehensive and holistic plan. You got to have proper insurance coverage, a proper retirement plan, whatever asset protection, and that's separate or in addition, but coordinated perhaps with the revocable trust. There's another piece of this, which is on slide 22, that just seems to fall between the cracks way too often. And so I just want to highlight that. If a client is coming in and you create a revocable trust to avoid probate, to manage assets during disability, to create, dynastic descendants trust, whatever other goals are met, one of the things that's important to do is look at all the ancillary appointments and designations and documents. And I just see this fall between the cracks all the time. And again, I'm going to say something in this context that I said earlier. Financial advisors are becoming more and more proactive in the estate planning world. Here's a great concept, an idea that can really be valuable to the clients. It's not technically very complicated, but they can identify, maybe even correct, some potentially nettlesome problems. And what do I mean? A lot of times estate planning is done piecemeal. So whoever did a revocable trust, are they doing a new durable power of attorney for financial matters at the same time? Maybe yes. And then maybe those positions, the agent under the financial power and the trustee under the revocable trust, are coordinated. Maybe it's the same person, maybe it's not intentionally. It depends on the facts and circumstances. But when you're looking at documents and reviewing an estate plan, who is named as the financial power of attorney? Who is named as the revocable trust? Should it be the same people? Should it be different people? And that may in part depend on how well funded the revocable trust is and what the application is for the revocable trust. For Social Security, clients can name a representative under the SSA's representative payment program that can even get and receive Social Security benefits. Who is that? Under long-term care coverage, you can name a lapse designee because of the high lapse rates of long-term care coverage policies. The industry has provided that you can name a designee to get notice if there's a problem. Well, who is that person? Was that person named 20 years ago, 10 years ago, and is no longer even alive or no longer in touch with the client? Is that the same person, a different person than the successor trustee under the revocable trust? And I'm not giving a standard answer because I think it always depends. Sometimes you may want different people. Sometimes you may want the same people. But the point is, often these ancillary or secondary, whatever phrase is appropriate, appointments, designations, or documents are not on the radar screen. They're not coordinated, and that can be quite problematic. Tom, we've mentioned already getting a tax ID number. Are there any other comments you want to make on that?
One of the reasons why clients do not want to get a tax identification number when it comes to the revocable trusts is it creates in many ways, it creates the need to file a 1041 grant or trust gift income tax return for the trust. Explaining to them how that's not that difficult to do and how all the income is reported on their personal tax returns may help allay those concerns. You want them to understand what it requires, but you need to talk about the advantages, which we've kind of already discussed here, potentially identity theft concerns. It creates another number that your accounts that are held in the revocable trust will be held under, but make sure that they understand the potential hurdles that will create as well. But an important point there is if you're filing an income tax return for the trust, it's also showing the IRS the existence of the trust and requiring the client and the CPA to think about the trust every year, which may help them with having follow-ups and making sure that, hey, is everything okay? How are you feeling about it? It helps create, like Marty mentioned earlier, some of that red tape that in this situation is actually useful to protect the client.
So my wife and I, as I said earlier, have revocable trust. We have tax ID numbers. I file a grantor 1041. I think it's important because it makes anyone who's on our team and involved in our planning aware that this thing exists, and I like that. Let's talk about some special revocable trusts. So revocable trusts can be used for owning a residence. Well, why might you do that? Well, because it could avoid ancillary probate. It could avoid probate. Do you put the house into a revocable trust? A lot of people do it without thinking further, but you need to ask a few questions. So for example, if the house is in a revocable trust, have I just destroyed the asset protection benefits that state law would provide if my spouse and I own the trust directly for tenants by the entireties? Many states recognize a special form of joint ownership between spouses as tenants by the entirety, and there's a measure of protection such that the claimants of just one spouse can't reach that asset. So before you transfer a house into a revocable trust to avoid probate, are you tainting, disqualifying that house for the asset protection that tenants by the entirety will provide? And that's something to give some thought to. If you have a young couple and they're both working as doctors or whatever high risk professions, that asset protection, which doesn't really cost anything, it's just the deed in their names, even if it's not a foolproof method of asset protection, which it's not, that still may be worth retaining rather than trying to avoid probate, which, barring a catastrophe, is not likely to happen for many decades in the future. Another consideration, when you have let's say a vacation home in a state and you put it in a revocable trust, you've now made it an intangible asset. If you live in a state that has an estate tax, you may now be subjecting that house to estate tax in your home state. Whereas if you continue to own it as real estate, because it's real estate, it's subject to the laws of the other state where the property is. And now you've just triggered a state level estate tax for no reason. Another concept to think about, sometimes it makes more sense to own the property in an LLC to avoid tax in a high tax state. So if you live in a no tax state, no state estate tax state, and you have a valuable vacation home in a state that has a state estate tax, you may now have triggered possible state estate tax. And sometimes a revocable trust may not be sufficient to break that. You may want an LLC to own it in order to avoid the state estate tax. And finally, and we can go on, but I think it's enough just to raise the issue so they're thought about. A revocable trust for a vacation home, you may prefer an LLC, for example, to provide some measure of liability protection that you may not otherwise get. Tom, do you want to talk a little bit about joint revocable trusts, and I'll fill in whatever you don't say?
Sure, but I just want to go back really quickly to talking about residences when it comes to revocable trust, just some of the practicality matters of that. If the client is going to transfer a home into the revocable trust, make sure they review their insurance, their home property insurance, to make sure that it's updated to reflect the revocable trust, or else they might inadvertently cause themselves to lose the protection. In addition, they need to consider any of the tangible goods that are held in that home. Are they going to transfer that to the revocable trust as well? Because that helps facilitate the co-trustee or the successor trustee helping pay the carrying costs, deal with any of the property in the home, and that's part of one of the reasons why you would want to do this. Joint revocable trusts, this is very much a state-specific consideration. What are the rules of your state? Do joint revocable trusts make sense? There are many practitioners that we know of that will consistently do joint revocable trusts, and that's a position that can be taken, and whether that makes sense for the clients or not, You need to consider while they're both alive, it's obvious they can both revoke it. It's grantor as to them. But what's going to happen if one of those spouses pass? How are you going to deal with it? Is it going to be partially grantor as to one of them, partially grantor as to the other? You also need to consider how you're going to create that joint revocable trust. Many times it's done so you could get a full basis step up on assets that are held in that joint revocable trust on the first spouse's death. Are you creating the trust in a way with provisions that causes that full inclusion in the first spouse's estate so that they get that basis step up? So this is going to be a little bit more state specific, but it's something that we as practitioners should look at. Does a joint revocable trust make sense for this particular client? Should they have separate trusts? Is there a tax reason to do so? Is there a practical reason to do so? So it's very much a per client and per state consideration here.
So in a community property state, if assets are held as community property and you put them in a joint community property revocable trust, you should get a full basis step up. In a non-community property state, there's no full basis step up on assets. And some practitioners believe that if they put these assets in a joint revocable trust, that somehow they're getting a full basis step up. I'm not sure that's really the result that occurs. There's another approach that can be used, and I credit the title to Alan Gassman, who I think first proposed the idea, called a JEST, Joint Estate Step-Up Trust. It's basically a joint revocable trust, and here's real simply conceptually how it works. If I put assets in a trust and I can revoke it, those assets are included in my estate, and there's a basis step up on my debt. On the other hand, if my spouse puts assets in the same revocable trust, those assets are included in her estate because she can revoke them. But if I die first, how do I get those assets included in my estate? So you can draft in the trust document that I have a general power of appointment over the assets she put in the trust, and my spouse has a general power of appointment over the assets that I put into the trust. So on whoever dies first, the assets you put in, that person put in, you get a step up. The assets from the other spouse, you get a step up because of the general power of appointment. That is not 100% clear either that works, because one of the arguments or concerns is, well, if my wife put assets in a revocable trust, how am I allowed to have a general power of appointment that's effective over assets that she has the unfettered right to revoke and pull out of the trust? So there's still a conflict there. So it's not clear that any of these joint revocable trusts work to get a full basis step up in a non-community property state. And if somebody is really concerned because there's, tremendous appreciation at getting the full step up, maybe what you do is look at an opt-in community property trust. I think Alaska, Kentucky, Tennessee, South Dakota, and maybe others permit these opt-in community property trusts irrevocable. That would work. So the joint revocable trust from a basis step up needs to be carefully looked at, especially in non-community property states. Another point, we have seen a lot of very awkward, problematic administrations of joint revocable trusts. So, for example, when someone creates a joint revocable trust, each spouse may have their own schedule where they put assets that are theirs. There may be a third schedule of assets that are joint between the spouses. It can get very complicated to maintain the proper titling and ownership and track what's going on. I've been very concerned where I see high net worth people doing that, and then there's large gifts made from the trust itself, and it becomes unclear who really made the gift. Perhaps if you're doing that and there's going to be large gifts made, you may want to have the assets retitled to the individual name so there's no uncertainty as to who made the gifts, and then make the transfers. Final point, I have some concerns over using joint revocable trust from the standpoint of asset protection. If it's deemed a joint revocable trust, characterized as a joint revocable trust, do I now subject the assets in that joint revocable trust to the creditors of either spouse? That's sort of the opposite result of the tenants by entirety ownership of a home we talked about a minute ago, where I suggested that a creditor of one spouse can't get at the assets, maybe, and I don't know the answer with certainty, and it'll certainly vary depending on state law, but maybe if you're creating a joint revocable trust, you may now subject the assets in that joint revocable trust to the creditors of either spouse. Not a great result. Here's a little bit of information on the gist, but we've kind of covered it. Tom, do you feel comfortable talking about using a revocable trust for divorce protection?
So a couple of different considerations here. One of the ways that when you're getting into a marriage, you can commingle assets is by not properly separating the assets that you had before that marriage. Another point is considering if you're going to inherit assets from somebody. Having a revocable trust creates a separate bank account, and if you use a tax ID number like we talked about earlier, a separate ID number that it's under, it reduces the possibility of having commingling, because that's now assets that you have separated. Even if you as the settlor are the trustee of that revocable trust yourself, it's reducing the possibility that you're going to inadvertently use those funds or put them in a marital account, and thus you've now tainted them as marital property forevermore. You can make distributions to accounts that are marital, at which point the assets that you're distributing out of the revocable trust are no longer considered separate property, but it's helping you have that level or degree of separation there. Same thing for inherited assets. And if you can, even better, if you never receive those inherited assets in your own name, if they can go directly into that inherited revocable trust, it's now never touched your personal name. So it's just another way to build a separation between these assets and to strengthen the argument that they're separate property.
Thanks, Tom. Let me give a little bit of framework and a few more comments. So first of all, if you're going to inherit an asset or be given assets, the unquestionably much better approach is the benefactor who's going to bequeath or gift you assets should create an irrevocable trust to benefit you. And how much control you have over that trust or don't have over the trust is a matter of discussion. It's pretty commonly thought that if you're the beneficiary and a trustee and you're limited to a HEMS, health, education, maintenance, support standard, that your creditors can't reach it, it may be more prudent based on some of the recent cases, especially if there's risks of how you act as a trustee, that you not be a trustee, you have an independent trustee, maybe only a discretionary standard, not HEMS. But the bottom line is it's clearly better and safer that an independent benefactor create a trust for you and make the gift or bequest into that trust rather than to you directly. So where does this concept of the revocable inheritance or separate property trust come up? Because the right planning wasn't done and whoever the benefactor was bequeathed outright to you. And that's often a result of this misguided concept that, oh, I want everything simple. So many clients, I want it simple. Well, simple is not generally the best result, because having things outright as opposed to in protective trusts as a general matter doesn't make sense. So now a client has assets in their own name, they're about to get married, or they're married already and they get a gift. Segregating those assets into a revocable trust, and even better with an independent trustee, even better with a separate tax ID number, even better if you can move it to a different financial firm so that there's less risk of commingling, at least is creating an identification, as Tom explained, to reduce the risk of commingling. A better approach, I think, across the board, but the problem with this approach is it's more costly, more complicated, and will cost more to maintain, is to create a domestic asset protection trust. So if you receive a gift or a bequest and you're married and you want to protect the integrity of those assets, while they're still separate assets, transfer them into an irrevocable trust. And some matrimonial counsel may have a question with that, because, you know, are you eliminating your right to the income or access to that? So I'm not saying that's a foolproof or definitely assured that it can work, but it's clearly a better result if you can do it. talk to matrimonial counsel before you do it. But if it's a choice between the separate property revocable trust that we're presenting or a self-settled trust, I would, unless matrimonial counsel says no, I would opt for the DAPT every day. Now, what will the separate property revocable trust do? Tom explained very well that it psychologically as well as mechanically makes it harder to commingle, and that's good. The other thing you can do is collect all the data and the corroboration to show that it is really separate property and attach it to the trust document and call it a separate property revocable trust. What it can't do is guarantee that in the event of a later divorce, that the income or earnings on the trust will also be ignored. I think it will, in many, I would like to say most, but I'm always cautious cases, protect the principal, but the court may count the earnings on that trust as earnings of yours in determining alimony, child support, and so on. But that's still a win because it means the property itself wasn't divided, say, 50-50 like other marital property. So that's already a home run to protect your assets. And again, the primary reason for doing this is to secure a less costly, less complicated approach for people that won't spend the money or won't spend the effort or won't endure the complexity of a self-settled trust. So what we're trying to do is show, just like we did with some really not significant modifications, how a revocable trust, which is a ubiquitous tool in planning, can be a more powerful tool to protect those with chronic disease, disability, or aging from elder or other financial abuse and so on and so forth, undue influence, et cetera. Well, here's another conceptual application where you can use a variant of a revocable trust just to try to protect assets from a future divorce. It's not the best protection, but it might be the right balance for many clients. Keep in mind, and it's a little beyond what we can do today, who's going to pay the income tax on the income in the trust. If you have a revocable trust of only separate property, not marital property, and you pay your income tax bill out of a joint marital account, the marital assets are being depleted to pay the income tax on the income earned by the separate property trust. It may be better to have that trust pay its own share of the income tax. And there's some more information on that as well. Before we go to the next section, let me talk about something that I'm tinkering with right now that I've never seen. And I came up with an idea, you'll be the first to hear it, that may work in yet another application. And by the way, because you can't do any kind of presentation without mentioning AI, and I give Tom credit, he mentioned it early in the program. Here's another AI comment. I think the two things that we as practitioners in all the allied disciplines will have as our turf for a while are creativity and dealing with the human aspects of planning. AI is going to probably do much of the other stuff very quickly. So here's what I think is a creative application. We had a situation where a beneficiary inherited outright under a parent's estate plan a reasonable chunk of money, call it $500,000. $500,000, you can't realistically, I mean, I guess you could create a domestic asset protection trust. It's just not enough money relative to the costs and the complexity. I mean, I mentioned it, but I didn't think anybody would do it. I don't think I would do it. But what do we do? And what were the circumstances? This particular beneficiary has a range of different addiction issues. And he started, because of therapy, to realize, like, oh my, I don't have enough impulse control. I'm blowing this money at a rapid clip. What can I do to make it a little harder for me to get at? And I came up with the idea of, call it, I didn't make up a name yet, so I'm going to make it up now, an addiction revocable trust. What do we do? What are we talking about? We haven't done it yet. So this gentleman, this heir, can take as much of the money as he's comfortable with and put it into a revocable trust, different tax ID number, different brokerage account, different bank, different financial firm. So you're putting a little distance between him and the money over which he doesn't have impulse control. Second step, what if we name a co-trustee along with him? If he's willing to do that, he can decide. What if we make both trustees, him and the independent trustee, have to agree for a distribution to be made? That doesn't change his power to be able to immediately revoke or modify the trust, but it's maybe enough that if he realizes he's got to ask Uncle Joe to sign off on a distribution, it may just give him enough breathing room so that he can evaluate, am I really supposed to take this money and get on a cruise and treat 3 of my friends? And maybe he has the lack of impulse control that he would do it, but having to get a sign off is enough to stop it. Depending on his comfort level, maybe Uncle Joe is the only trustee. Maybe he's not even a current trustee. And if he's only putting part of his wealth in there and has some money that he can still spend, maybe that's a protection over this. He can decide. We talked earlier in the context of planning for aging, how you can have the requirement that a non-adverse party, the attorney, the accountant, a religious advisor, has to approve a modification or revocation of the trust. Maybe he'll be willing to do that. Again, we're trying to create some impediments that don't take away his ability to control his money, and hopefully he'll get through these problems and mature, and he's doing a great job with therapy right now. But and think about how good he's doing to be able to recognize that he has impulse control issues, right? I'm almost 70 and I can't recognize that. So you can take and evaluate separate accounts, separate tax ID number, co-trustee, co-trustee required to sign, co-trustee either can sign, successor trustee or a full independent trustee. You can have a trust protector that has certain powers and rights. You can have somebody who has to approve revocation or modification. Whatever, I'm giving him a menu. He can check off whatever he's comfortable on the menu. You draft a pretty simple revocable trust at modest cost, and we've now created impulse control safeguards using a common standard, fairly standard revocable trust with the techniques that we all know how to use. So I think that's another interesting application of revocable trust. Tom, we're getting out of time. Let me just run through the last point. This is crazy, but I just want to show you how crazy can be. I had a client many years ago who was buying a cooperative and wanted it in their revocable trust. And the attorney for the cooperative, the third bullet point, they basically said you can't change your revocable trust unless the managing agent for the co-op agrees to that change. Crazy. But you got to be careful, and as the caption says, read the fine print. You got to be careful what kind of so-called standard stuff clients sign in planning, and this was just in the context of a revocable trust. Tom, why don't you give a quick summary and we'll call it a day?
I think one of the things to take away from this entire program is the sheer breadth of planning ideas that you can incorporate into a revocable trust, the myriad of different ways that it could be used to help clients, whether it's from aging to a beneficiary that has impulse control like Marty just talked about, whether it's building safeguards in for any issue that we talked about today. The revocable trust can be considered the Swiss Army knife for estate planning. It's a great way to really help clients create a plan for themselves that they may not have been able to do without the use of the revocable trust. So consider, when you're talking with clients, what a revocable trust makes sense for them, what particular powers can we put in there, and how do we approach it to explain to the client why it could be so much more than just a way to avoid probate.
I encourage all advisors to think more creatively, think out of the box, think holistically for the client sitting in front of you. We've tried to give a number of different applications, from basis step-up planning to probate avoidance to disability to cognitive issues to divorce planning to addiction issues, all using a fairly common revocable trust as the chassis on which to build a plan. And it's not that expensive. It's not that big of a deal. We can do a better job for a client when we focus on what does this particular client sitting in front of me need versus what do I have in my standard form. And with document generation software, which I encourage everyone to be using, and I don't think AI is quite doing the same thing the way I've seen it applied, you can creatively tweak and get really incredible results. This is also a warning to the clients and even the advisors that think, oh, it's a standard revocable trust. I think we've demonstrated there is no such thing, and you're not getting the best results if you have a standard or boilerplate anything. So thank you for joining us, Tom. Thank you, and I wish you all good luck. And we always welcome your feedback, thoughts, or ideas. Thank you.